joining, everybody. My name's Helen. I'm from Thornfields, which is part of First Practice Management Group. Welcome to the webinar today. It's on the topic of safer recruitment and going to be delivered by our HR consultant, Kira Burns. So I'm going to hand over to Kira now, and she will take it from there. So thank you very much, Kira.
Thanks, Helen, for the introduction. So good afternoon, everyone, and welcome to our webinar today on safer recruitment. My name is Kira Burns. For those who do not know me, I am the HR consultant here at FPM and Stericycle. Today, we'll delve into the critical importance of safer recruitment. I have tailored the content today based on queries I typically receive into the HR helpline. The aim today is to equip you with the knowledge to navigate your recruitment processes safely and confidently. I'll just move to the next slide. So we will explore the topics that you can see in front of you on the screen, including what safer recruitment means, legal requirements and best practices, the policies and procedures required to ensure your recruitment practices are fair and compliant, and we will also discuss common pitfalls of recruitment that you can avoid, and explore tribunal and legal cases. As Helen mentioned, I will leave time at the end to answer questions already submitted before the webinar and those submitted during. I also want to note that we have professionals from both primary care and the dental sector with us today, and because of this, I will be addressing the requirements of safer recruitment for both sectors when I discuss the CQC and the General Medical Council inspections. Okay, so we'll just move to the next slide. So what does safer recruitment mean? Safer recruitment means having the right number of staff with the right skills and experience to deliver safe and effective care to patients, and that they have been suitably checked to prevent any harm to patients. So how can we satisfy this statement and ensure that our procedures are fair? Employers first need to have an understanding of what their legal obligations are, and then they need to implement appropriate policies and management procedures to ensure recruitment practices are fair and compliant. Understanding the legal obligations and implementing such policies will help you protect those in your care and maintain a safe working environment. The legal requirements and best practices for safer recruitment in the UK are designed to ensure that you're recruiting individuals who are qualified, suitable and trustworthy. Let's look at conducting a right to work check. This is a legal requirement for employers. Employers must verify that every candidate has the legal right to work in the UK before employment begins. This involves checking and copying original documents such as passports, visas, or biometric resident permits. Just to note, the biometric resident permits are being phased out by December 2024. Many of the cards will list a valid until date of the 31st of December 2024, but the actual visa expiry date may be later than this. But after the date of the 31st of December 2024, individuals can use an online portal with the Home Office to provide evidence of their immigration status by accessing an online view and share feature that allows them to share their visa status with employers. Just to note, if you do employ someone who does not have a legal right to work in the UK, this can result in fines of up to £20,000 per illegal worker and potential criminal charges. So it is something just to think about if you have anyone working for you who needs a visa to work in the UK, or if they have provided you with a biometric residence permit, you should request their visa status from the Home Office portal, as this process will change from the 1st of January 2025. So disclosure and borrowing service checks. There isn't a legal requirement to conduct this for all jobs in the UK, but they are required for certain roles. So for roles that involve working with children, vulnerable adults, or in certain regulated professions, and in this case, healthcare professionals, employers must conduct DBS checks to assess a candidate's criminal history. So there are 4 different types of checks. They are a basic check, which shows unspent convictions and is not role specific. We have standard DBS checks. This includes spent and unspent convictions, cautions, reprimands, and final warnings. We have enhanced DBS checks. This includes the same as a standard check, plus any additional information held by the police that's considered relevant. And then we have the enhance with the barred list check. So this includes everything I've just mentioned, plus a check against the DBS barred list, which identifies individuals who are barred from working with children or vulnerable adults. So next, we'll just take a look at the equality and non-discrimination laws in the UK. So these aren't just principles to strive for, they are a legal requirement, as the Equality Act places an obligation on employers to treat individuals fairly and without bias. So under the Equality Act, recruitment processes must be non-discriminatory. This means employers cannot discriminate against candidates based on protected characteristics such as age, disability, gender reassignment, race, religion or belief, sex, sexual orientation, marriage and civil partnerships, and pregnancy and maternity. You have an obligation as an employer to ensure that job adverts, application forms, interviews, and selection processes are inclusive, accessible to all candidates, and free from discrimination. Verification of qualifications and professional registrations is not a blanket legal requirement for all jobs in the UK, but it is mandatory in certain regulated professions and industries such as healthcare. Employers must verify that candidates hold the necessary qualifications for the role. For regulated professions such as doctors, nurses, and dentists, employers must check that the candidates are registered with the appropriate professional bodies, for example, the General Medical Council or the Nursing and Midwifery Council. Data protection. This is a legal requirement that employers must follow. So you are required to handle candidates' personal data in compliance with the General Data Protection Regulation. This includes collecting, processing, storing, and disposing of data in a lawful, fair, and transparent manner. Employers must ensure that candidates are informed about their data and how it will be used. Non-compliance with GDPR can result in the Information Commissioner's Office, also known as the ICO, investigating your practice. While reference checks are not a legal requirement, obtaining references is considered best practice in safer recruitment. You should seek references from previous employers to verify a candidate's work history. Ensuring compliance with these legal requirements and best practices during the recruitment process is crucial for protecting your organisation and the people you serve. By understanding your obligation, you can minimise risk, promote fairness, and maintain high standards of care and service. So, how can you ensure your legal obligations as the employer are adhered to, and how can you incorporate best practices into your recruitment procedures to ensure that your processes are safe and compliant? The answer is your policies and procedures. The policies that you can see in front of you: the recruitment policy, data protection policy, rehabilitation of offenders policy, DBS check-in policy, your complaints procedure, and whistleblowing policy. They all provide the framework for fair and effective safer recruitment practices. So let's discuss the recruitment policy. This policy, to me as a HR professional, is the most important when dealing with recruitment, as it outlines the hiring process. This policy can help deter, reject, or identify people who might abuse young children and or vulnerable adults, and it is a crucial part of the safeguarding process. Your recruitment policy should cover information on how you write the job description, how you shortlist potential candidates, when to conduct a DBS, your reference checking process, the interview process, and how induction, training, and probationary periods are managed. Your safer recruitment policy should show how your organisation is committed to recruiting those who are suitable to work with young people and vulnerable adults, and it should show how you identify and reject those who are not suitable. The policy sends a clear message that the safety of young people and vulnerable adults in your care are first and foremost, and ensures that your staff are aware of their safeguarding responsibilities. But there are other policies that are equally important, such as the data protection policy. When you receive an application form or a CV, you are receiving personal data such as names, addresses, date of births, and some application forms often request national insurance numbers. This is all personal data. You need to have a lawful basis for processing personal data, and you need to be transparent about how you collect and use it. Typically, employers confirm how they will use this data on the advertisement or application form. It is important to note that applicants do have a right to access, rectify, erase, and restrict and object to the processing of their data by submitting a subject access request, and you need to be prepared to respond to that request within the required timeframe of 1 month. All that being said, if you have secured the data using the right methods, then it should be straightforward to complete a request like this. However, if you haven't secured the data or responded to the SAR within the required timeframe, the ICO, the Information Commissioner's Office, take complaints like this very seriously. An example of this is, say you have an applicant who has requested that you restrict their data, and you've not done this. You haven't responded to the SAR request. You then have a receptionist who has nothing to do with the recruitment process, but she notices an old friend or a family member coming into the surgery for an interview. They access the applicant's data on the company intranet with ease, as it was unsecured. It didn't have any restricted access. And they then contact that individual. Oh, I see you're applying for the position of lead nurse. You could then receive a complaint from that candidate that our request and restrict their data. They could then make a complaint to the ICO, where you could be subject to an investigation. You could receive a reprimand, which is a formal written complaint where you have failed to comply with data protection laws, which is then published on the ICO website and could potentially damage your organisation's reputation. To conclude on this point, strong data protection practices are essential for ensuring a safe and compliant recruitment process. By safeguarding candidate information and adhering to legal requirements, organisations can protect their reputation, build trust, and mitigate the risks associated with data breaches. So let's move on to discuss the DBS checking policy and the rehabilitation of offenders policy. Your DBS policy should define when and how DBS checks are conducted and how you can mitigate risks associated with vulnerable groups. In both dental and primary care, the level of checks required depends on actions. Conducting DBS checks are a vital step of safer recruitment procedures, as it demonstrates, again, your commitment to safeguarding. If you fail to conduct a DBS check, it can lead to enforcement action, including warning letters, financial penalties, or even suspension of registration, and you could be putting others at risk. It is important to note that DBSs do not have an expiry date. The information provided on the certificate is accurate only up to the date it was issued. It is recommended that you renew a DBS every 3 years, and for some roles they require more frequent checks. Also, some insurance policies may not cover the practice in the event of an incident if a DBS has not been carried out when required. So you might need to check your policy to see if you are following the terms of your insurance policy agreement and if you are carrying out DBS checks when required. You should also have a rehabilitation of offenders policy, or a section on this should be included in your DBS policy. The Rehabilitation of Offenders Act gives people with spent convictions the right not to disclose them when applying for most jobs. However, it is important to know that those who work with young children or vulnerable people must declare their convictions. The primary reason for conducting DBS checks is to safeguard individuals in care. It is not done simply to avoid penalties or as a tick-the-box exercise. They can help you identify potential risks and help protect vulnerable patients and your staff. This in return creates a safe environment and demonstrates your commitment to your patients and employee safety. So we'll just move on to the equality and diversity policy, which is also important for safer recruitment. During the hiring process, you must ensure that you abide by the Equality Act. This is to ensure that you do not discriminate against any applicants. Discrimination is the unfair treatment of an individual due to a protected characteristic. And there are two main types of discrimination. There are direct discrimination, when someone is treated differently due to a certain trait. Indirect discrimination, where policies or a rule are implemented to have a negative impact on someone due to a certain trait. Throughout the hiring process, there are steps that you can take to avoid direct and indirect discrimination from occurring. For example, when you're creating job adverts and job descriptions, it is vital to ensure that the advertisement does not use gender terms, such as a salesman. If you have application forms, they should be easy for candidates to complete and should include instructions that are easy to read and not be overcomplicated. When shortlisting candidates, you should use the skills required on the job advert and job description to assess applications. This is to ensure fairness in the screening process. You should try to use more than one person to conduct the shortlisting, as this eliminates any bias. When interviewing candidates, you must check if they need any reasonable adjustments to assist them during the interview. Don't ask any questions relating to a candidate's age, marital status, sexual orientation, whether they intend to have children or not, as these questions can all be deemed as discriminatory. The advice is that you should ask the same questions to each candidate to ensure fairness and try not to go off topic. You should have a fair scoring system to score each candidate, keep records and notes of the interview, and what questions you asked and what the candidate's responses were. By adhering to the Equality Act throughout the recruitment process, you can create a fair and inclusive environment for all applicants. And lastly, let's discuss your complaint and whistleblowing policy, which are equally important. Your complaints procedure provides a clear pathway for candidates to raise concerns and for you to address complaints and misconduct related to the recruitment process. Whereas the whistleblowing policy encourages employees to report any suspicions about a new hire or existing staff member. This could include concerns about their suitability of the role, potential misconduct, or red flags during the recruitment process. Think of it this way: your complaints procedures protect candidates and improve processes, whilst your whistleblowing policy safeguards employees and the organisation by detecting potential issues early on, and both contribute to a safer recruitment process. Having a clear understanding of the purpose and importance of the policies listed in front of you is fundamental to the success of safer recruitment, and it can help you pass part of your inspection with the Care Quality Commission and General Medical Council, which I will discuss on the next slide. The CQC oversees both primary and dental practices, while the GMC focuses exclusively on dental professionals. Although their focus areas differ, their approaches share key similarities, especially concerning patient safety and staff suitability. The similarities are that both regulators emphasise the importance of recruiting individuals who can deliver safe and effective care. During inspection, they check whether staff have been properly vetted to ensure they are suitable for roles involving patient care. Both regulators mandate the use of DBS checks for staff working with vulnerable groups. This ensures that employees do not have a history that would render them unsuitable for such roles. Inspections also include verifying that candidates hold the necessary qualifications and that they are registered with the appropriate regulatory bodies. Both the CQC and GMC stress the importance of maintaining detailed records of recruitment processes, including applications and CVs, interview notes, DBS checks, and references. However, there are key differences. The CQC focus is on the overall safety and quality of care across these sectors, ensuring that recruitment policies and procedures align with Regulation 19 Fit and Proper Persons requirements. This regulation ensures that individuals who have a role within healthcare are suitable for that role. During a CQC inspection, the focus is broader as they look at how the practice's recruitment procedure contributes to the overall quality and safety of care. The checks typically include a review of HR processes, staff training, and safeguarding protocols, whereas the GMC, who specifically regulate dental professionals, focus on the standards of education, training, and professional conduct of people employed within the dental sector. Their interest in recruitment is more narrowly focused on whether dental professionals meet the required standards of practice and if they are properly registered. To help you pass the safer recruitment aspect of both CQC and GMC inspections, you should ensure compliance with legal requirements. Ensure that you're conducting DBS checks as required and verify that all staff have the right to work in the UK. And ensure that all healthcare and dental professionals have their qualifications and professional registrations verified. You should have a strong and comprehensive recruitment policy. Align your recruitment processes with the standards set by both the CQC and GMC. Your policy should cover the entire recruitment process, from job descriptions and role advertisements to interviews, hiring decisions, inductions, and how probationary periods are managed. Maintain detailed records of every stage of the recruitment process, including copies of identity verification documents, again, references, professional registration checks, and ensure that these records are readily accessible for inspection. You should prepare your team by training your staff who are involved in the recruitment process on the legal and regulatory requirements, and make sure that those who are responsible are aware of what inspectors from both regulators will be looking for during an inspection. Regularly review and update recruitment policies and procedures to ensure that they remain compliant with current legislation and best practices, and conduct internal audits of your recruitment records to ensure ongoing compliance. As I mentioned earlier, there is an overlap between the two regulators, particularly in areas like DBS checking and qualification checks. To successfully pass this part of the inspection, practices should have robust recruitment procedures supported by detailed staff records. Just to let you know, after the webinar, we will share information in our guide on where you can find toolkits and advice from both regulators that will assist you with passing inspections, in particular, the safer recruitment aspect of inspections. So let's move on to the next slide, where we will discuss common pitfalls of recruitment. So there are several common pitfalls that can undermine the effectiveness of recruitment efforts. In front of you, I have listed some of the recruitment pitfalls that I've picked up on when I received queries from practice managers on the HR helpline. So the first one is failure to conduct reference checks. What are the risks of skipping reference checks? When you hire a new candidate, you want to know everything about what it's like to work with that person, but majority of employers simply confirm the dates of their employment and their job title. It doesn't actually tell you much about their job performance. However, it is important to verify, as you need to check their employment history. Some employers have skipped this step in the past, as it is an illegal requirement, but it can lead to significant risks, as you could hire an unqualified candidate, which can increase the likelihood of misconduct, and this can go against you when the CQC inspect your practice, as it is part of their inspections. Reference checks are crucial for verifying a candidate's previous employment history, and skipping this step could lead to hiring mistakes that could easily be avoided. The advice is you should not allow an employee to start employment until you have received 2 satisfactory references. Ignoring cultural fit. Do they align with your organisation's culture? So hiring solely based on skills and experience without considering how well the candidate aligns with the company culture can lead to poor team dynamics and low employee morale. It's a two-way process where the candidate and the organisation should be a good match. Employees who don't align with the company's values are less likely to be engaged, which impacts productivity and retention. To ensure new employees fit well with your company culture, you should start by clearly defining your organisational values and what your work environment is like. You should then incorporate these cultural aspects into job descriptions to attract the right candidates. During interviews, you should ask questions that can reveal how candidates' values align with your organisation's values, and you can do this by asking behavioural questions during the interview. Overlooking soft skills. Are soft skills overlooked in the hiring process? So while technical skills are important, overlooking soft skills such as communication, teamwork, and adaptability, they can result in hiring candidates with technical excellence who sadly struggle to collaborate effectively as they don't have the soft skill to do so. This is one of the most common hiring mistakes every hiring manager should try to avoid. It is essential that you evaluate both technical skills and soft skills during the interview process, and this can be achieved by incorporating a range of interview questions using both technical questions and behavioural questions to gauge a candidate's expertise and interpersonal abilities. And lastly, failure to verify qualifications and professional memberships. Are you checking qualifications and professional memberships? So this is so important, and it can often, in many cases, be overlooked. It's not just about ticking a box. It's about protecting patients, adhering to safer recruitment procedures, and maintaining the practice's reputation. So by conducting comprehensive checks, you ensure that your staff are genuinely qualified and protect your practice from potential risks and legal issues. I am surprised myself by the amount of tribunals and legal cases that I have come across lately where employees have lied about their qualifications, which could have been discovered early on if checks, a detailed check that is, were carried out. So I'm just going to move to the next slide where we will discuss tribunal and legal cases. So in front of you, you can see Miss Lee versus R&F Properties. In this case, Miss Lee won more than $90,000 for sex discrimination after a prospective employer withdrew a job offer after asking her how old her children were. So Miss Lee applied for a post as a real estate marketing manager at the London offices of R&F Properties, which is a Chinese real estate company. She attended 2 interviews and was offered the role. A contract was signed in late September 2022 with a start date on the 1st of November 2022. Naturally, she handed in her notice at her current role, and she raised the need for flexible working during her interview, and she was told that she could avail of this once she passed her probationary periods. On the 20th of October, 12 days before she was due to start, she attended a Microsoft Teams meeting with the marketing manager. And at the start of that meeting, Miss Lee stated that she needed to ensure that she finishes the meeting on time to attend to her children. During the meeting, they discussed her work experience, the size of the projects she previously worked on, and what clients she previously dealt with. However, towards the end of the meeting, out of the blue, the manager asked her how old her children were. She stated that one was 4 and the second was approaching 1 year of age. She said that she left the meeting feeling deflated, confused and frightened. She was stressed and worried that the job would be taken away because of the things that the manager said, and the question asked about her children's age really stood out to her. By the 26th of October, the job offer was withdrawn. This was later followed up in writing. After the role was withdrawn, Miss Lee made a claim to the Employment Tribunal alleging that in asking the age of her children and in withdrawing its job offer, R&F Properties had directly discriminated against her because of her sex. She told the tribunal that the question came out of the blue and had no relevance to the items discussed in the meeting. R&F denied that they were discriminating against Miss Lee. They argued that the question was asked on a get-to-know basis to build up rapport, and that they would have asked a man the same question. They stated that the decision to withdraw the offer had been taken as a result of it needing to reduce headcount. Throughout the hearing, the tribunal said it was under the impression that the company was denying the manager had even asked the question. However, a record from an internal chat from February 23 showed that he had denied asking the question about her children, but evidence from another chat in November 2023 suggested that he did ask about the children's ages. The company argued that around the same time of this meeting, the manager was informed by HR, the headquarters in China, that there needed to be a recruitment freeze, which led to the job offer being withdrawn. But the tribunal found that it was more likely that the head of HR instructed that the contract be withdrawn following the conversation in which they found out the age of her children. The judge rejected the argument that the manager would have asked both a man and a woman the same question regarding the ages of their children. The tribunal stated that in their experience, it's not common for a man to be asked the age of his children. And further to this, R&F Properties, they couldn't provide any substantial evidence that they needed to reduce their headcount. So the Employment Tribunal ruled in her favour and found that she had been directly discriminated against because of her sex, both at the time of the manager asking the age of her children and when the job offer was withdrawn. As a result of this, R&F Properties have been ordered to pay Miss Lee over £90,000 in compensation, including awards for injury to feelings and financial losses, including lost earnings, pension and nursery fees. So the decision in this case serves as a clear warning to employers that engaging in conversations during interview and planning meetings that have no relevance to the role in question and which relate to a protected characteristic could lead to allegations of discrimination. To reduce the risk of claims of discrimination, employers should be careful only to ask questions of candidates which are relevant to the role. I suppose this does go back to my point that I made earlier. All candidates should be asked the same questions, and the interview panel should not deviate from the list of questions supplied. And if you are withdrawing a job offer, you should have evidence to support the reasons for doing so. So I'll just move on to a legal case that I came across. So neonatal nurse Tanya Nasir, who faked her CV to get a senior position. So Nasir was a ward manager on the neonatal unit at the Princess of Wales Hospital in Bridgend in September 2019. She lied about her experience and qualifications to get a job as a senior nurse in a unit for sick and premature babies. So Nasir was accused of 9 counts of fraud and false representation, which she still denies. However, she has since been found guilty of fraud. She made out that she was a highly qualified neonatal nurse, an army combat medic who had been shot at twice in Afghanistan, and someone who had a raft of clinical and academic qualifications. The truth is, she tricked her employers, colleagues, and even close friends. 4 months after she started work as a manager, as the ward manager, the unit's matron became suspicious after a check on Nasir's nursing registration code, which showed she had qualified 4 years later than she had stated on her application form. The hospital began an investigation as it was discovered that Nasir had spun a web of lies about her life and her nursing experience. She was suspended, but she resigned 2 days before disciplinary hearing. She had claimed to have worked with premature babies at the Chelsea and Westminster Hospital in London between 2010 and 2015, but there was no record of her ever being employed there. She also claimed to have worked for the West Hertfordshire Hospital Trust and in the adult intensive care unit at Watford General Hospital. Again, there was no record of such employments. She provided further false information by exaggerating her qualifications. She said she had qualifications including degrees in physics, a BSc in operating department management, and her registration document with the Health and Care Professionals Council, which she actually needed to become a ward manager, was also fake. Miss Nasir had also falsely claimed to have served in a number of roles with the army, including as a platoon commander and combat medical officer with the Royal Medical Corps in the rank of major. In fact, she had actually failed the basic fitness test for the Army Reserve in 2010. She spent 3 years with the cadet force before being discharged and struck off in 2016 as the rank of sergeant instructor. It was also confirmed that she had never been deployed overseas as an adult volunteer. She said she had also served in Haiti, Syria, Kenya, and Iraq. And she said she was shot at twice while serving in Afghanistan. She also claimed to have worked with charities, including Oxfam and the Red Cross in war zones. The charities confirmed that there was no records of her working with them. She even went as far in the job interview to ask if she could have time off during the summer of 2020 to attend an army training camp on the Indian Ocean island of Diego Garcia. So a further claim that she made was that she obtained a PGCE program, which is the first step towards gaining an MSc from the Royal Military Academy at Sandhurst to become a qualified army teaching instructor, was also false. So with regards to her references, an old email address for Matthew Nash Yearwood, a major in the cadet force who was given as a referee on Miss Nasir's CV, was also false, and in reality an account operated by Miss Nasir. She also faked her reference for the neonatal manager's post by using an NHS email account belonging to an old colleague that she worked with in London that she actually logged into. In the reference, she wrote that she had been her line manager, which again was all a web of lies. When her home was searched by police after her arrest in 2021, fake certificates and diplomas were discovered. She deliberately lied about her qualifications and employment history so that she could gain employment in a senior and sensitive nursing role where she was trusted with the responsibility of caring for newborn babies. I think what stood out for me after I read this case was the comments made by her previous employer in London. They said that their record showed no formal concerns were raised about her qualifications or experience. So that tells to me that there is some sort of a failure in their recruitment procedures, and they really should have noticed the inconsistencies on her application form against the nursing registration code. She has since been found guilty and she is awaiting sentencing, which will be on the 24th of September 24. Myself personally, I am keen to know what the sentencing will be, because in the next legal case that I'll speak to you about, which is quite similar in nature to Ms. Nasir's, there was a sanction of a prison sentence and a fine imposed. So it will be interesting to see if Ms. Nasir will face the same outcome. So let's just look at John Andrews, who was appointed chairman of the Royal Cornwall Hospitals NHS Trust. Bear in mind that this person got this post ahead of 117 other candidates. No one on the high-powered panel who conducted 2 interviews with Mr. Andrews for this post had any doubts that they had chosen the right man for the job. Outstanding is how they actually described him. So his CV made him look as if he had invested many years into education. It included joint first class honours and a Master of Philosophy degrees from Bristol University. He said he had a Master's of Business Administration from Edinburgh, a PhD from Plymouth University, and he also said he had a diploma from the Chartered Institute of Management Accountants. The 69-year-old spent a decade working as a chairman for 2 NHS trusts and as the chief executive of St. Margaret's Hospital, which is a hospice, which is a palliative care charity in Somerset. And he started on an initial salary of £75,000 a year. Well, he actually shouldn't have got any of these jobs, as all his qualifications were made up. He started life as a builder before gaining a diploma in social work, which was his only real academic achievement. His lies were so convincing, the organisations believed he was a fit and proper person for the job, even though he claimed he had been an executive officer at HM Revenue and Customs in 1969 when he was just 16 years of age. The offending only came to light after St. Margaret's Hospice conducted a review at the request of NHS investigators. So when attempts were made to examine his human resource personnel file, which Andrews had access to, it could not be found. So he did earn over 1 million before tax in 12 years, not just from the NHS, but also from a number of charities that he ran. Most of this was spent before he was caught. He was jailed in 2017, and the Supreme Court ruled that CV fraudsters like Andrews may have to pay back the proceeds they made under the Proceeds of Crime Act. So he actually was ordered to repay back almost £100,000. So it is hard to believe how he rose to such prominence in the NHS on the back of fabricated credentials. And some will ask, how was this even possible? So the answer really is no due diligence was carried out when he was appointed to these roles in the NHS. I suppose both cases I have just mentioned, Nasir and Andrews, they highlight just how important it is for employers to check the employment history and educational history. And just to point out that there are more similar cases to the ones that I've just spoken about. A simple Google search will show you the number of cases that are just so similar in nature, and they keep happening as well. They do serve as a stark warning for employers across all sectors, as it highlights the critical importance of robust recruitment and verification processes. So it is vital that you carry out comprehensive background checks on all potential employees, especially for roles requiring higher level of trust and responsibility. Relying solely on written references is insufficient. You should consider conducting in-depth reference checks, including phoning or video calls to previous employers. Direct verification of qualifications with educational institutions is crucial. You should avoid relying solely on certificates or transcripts provided by candidates. By taking these steps, you can significantly reduce the risk of hiring individuals with fraudulent backgrounds. And again, just protect your organisation from potential reputational damage and legal claims. So I will move to my last slide. So just to wrap up, remember, safer recruitment, it means having the right number of staff with the right skills and experience to deliver safe and effective care to patients, and that they have been suitably checked by you to prevent any harm to patients. It's important to continuously learn from past experiences and be ready to adjust your policies as needed. Above all, never think that enough has been done to ensure a safe culture. Here at FPM, we do offer a comprehensive policy library that includes policies such as the Safer Recruitment Policy, Equality and Diversity Policy, and Data Protection Policy, and so on, which are tailored to suit both dental and general practices. So those policies can assist you with implementing and maintaining effective safer recruitment practices. So if you are interested in becoming a member, or you are a member and you need to access those policies, you can contact me on the HR helpline. The details are there in the screen in front of you. Okay, so that's everything for now, Helen. So I suppose we'll move just to questions and answers.
Yeah, we've got quite a few questions. So thank you for that, Kira. That was really interesting and useful. Just before I go on to the questions, it actually sounds really scary to me that you know, especially those cases that you highlighted. So obviously, Kira's already mentioned that we do have all of the policies available if you would be interested in learning more about how you can access them. Through Thornfields, we do have a workshop called Recruiting the Right Person. So if this is a bit of a worry to you, then you can learn more about it. And also we do offer a full recruitment service as well, where we have an experienced consultant, which will ensure that you don't get into any of these tricky situations. So I just wanted to mention that. But we have got quite a few questions, and we've got about 15 minutes left. So I'm going to quickly go through them. The first one was asked by Paul, and you did actually answer this, but just to clarify, first of all, can employers rely on a previous DBS check, or should they carry one out when employing new staff? You did respond to that, but just to clarify, what exactly would your thoughts be on relying on one if it was done fairly recently to recruitment?
I wouldn't
what would you
rely on
recommend?
it. I definitely wouldn't rely on it, just based on the cases that I've come across. I would suggest that you conduct your own DBS check, and it's just to protect yourselves. Even if you do a search yourself on the cases and the things that some people have done to get a role, the lies that they create, you just can't trust it. So I would genuinely, I would recommend carrying out your own DBS check.
Yeah, I would agree, yeah. Okay, and Chelsea has asked, can you turn down an applicant because they're overqualified?
That would be, I suppose there's no real law or rule on that. I suppose that would just be up to yourself. I mean, if you think about it, if you employ someone that's overqualified, they're probably not going to stay in the role for long. So it'll be up to yourself as you do speak to them. You'll be able to see if they're a good fit, like what their long-term goal is, and then you'll be able to look at your own organisation. So can they go into this role now, and can they progress into another one? Will we have something that suits them better? But more than likely, someone who's applying for the role, if they're overqualified, they're not going to stay with you long term.
But it's not illegal. It's not. It wouldn't be. No.
No. It comes down to seeing, are they a good fit? Like, someone who's overqualified might not necessarily be a good fit for that role either. But you will be able to determine that at interview.
Yeah. Okay. Okay, so the next one's from Sue. So if they've offered a role to someone who has accepted but is now being very slow to give a start date, can they retract the offer? Personally, Sue feels it could be in breach of contract.
So have they given a start date, the employer themselves, but the employee hasn't agreed to it? Is that what that is? I wonder, maybe Sue, if you could provide more information and I could address that one offline, because if you give a start date to an employee, like they should start on the date that you give them. Now, sometimes there is exceptional circumstances where they can't, I don't know, they could be sick or they might have a bereavement, but realistically they should be starting on the day that you give them. So I'd be keen to know why or what reason they've given you as to why they're not starting. It shouldn't really be up to the new employee. It's up to the employer to set that date.
Okay, so if you want to discuss that in more detail, just drop me an email, or you can put your details in the chat if you wanted to. Okay, Elizabeth, can you check more than their last previous employer as well as a personal reference?
Yeah, myself personally, I don't like personal references because it's normally like a friend or a family member or someone that might not be a professional within the industry you work in. I always tend to say look for 2 references. That normally is enough, and that's what the CQC actually look for as well. And it is best practice just to have 2. But you kind of have to go with what they've given you. You just need to make sure that is that enough for you, in the sense that do you trust that reference? So if it is a personal one, I would be going back to the candidate and saying, is there any chance you can give me 2 professional contacts to reach out to, just to secure yourself? And some people might not have 2, they might only have 1. But again, based on everything else you've done, such as your DBS checks, the interviews, you'll be able to know initially if you can trust them to join the organisation as well.
Thank you. Okay, Sarah, can you withdraw an offer if you're unhappy with the references being supplied? For example, they have given no substance and very vague. And actually, that was another question that we had submitted, similar. Yeah. So how can you ensure that you're still making a safe and informed decision without any information on the performance and conduct?
Well, if you think about references, first of all, you need to consider if it's a conditional or an unconditional offer. So are they going to get the post regardless of references, or is it part of the agreement to hold the post? So that's the first thing. And then the second thing is, when you think of references, don't think of it as a character reference. It is only an employment history check. So majority, if not all organisations in the UK, they don't, employers in the UK, they don't provide detailed references or any reference at all, because they might have a strict policy not to do so. So yeah, I wouldn't be, don't be basing it off of character, just based it off of the employment history dates itself. It's just checking to see, did they actually work there? Does that employer know who they are? And when it comes to withdrawing the offer, it depends. It could be part of your agreement to be able to be in that role, or it might not be. So if it's conditional or unconditional.
Okay. Sarah, I hope that answers your question. If you'd like more information, again, just drop us an email. Paul says, thank you for the DBS advice. Haley, is the process between offering the job and getting the information together for a start date, are there any deadlines? So if it takes too long to get that information from the person.
What information, sorry, was it, Helen?
Is the process between offering the job and getting the information together for a start date, or any deadlines?
Maybe they're referring to like their qualifications or references. What I would say to you, I would not let an employee join an organisation without all that information already there. Like, that should be part of your onboarding process, and onboarding starts the minute you give the offer of employment. And until I get that information, I wouldn't be confirming a start date. So no matter what documentation, just given the nature of your roles and because it is so sensitive and you do have those safeguarding, you do have to safeguard your patients, I just wouldn't allow an employee to start without that information, if I'm being honest.
So just to add on to that, Kira, so if they had offered the job and then they took too long to provide the information that was requested, can they withdraw the job offer?
you have to be very careful about withdrawing the job offer. So first, I would just ask the employee why they haven't given you that information. What is the delay? Set a date when they do need to send it to you. Again, if it is a requirement of the job offer that you need this information before they're made a member of staff, then yes, you possibly could withdraw. But if it's not part of your offer, then you can't really. And when you do withdraw, there's just a lot of risks with it. Like you will have to pay them notice pay as well, to remove them from the role, even if they haven't even if they haven't even been in the role for an hour, you will have to pay them. But what I can do on that particular question, I can provide a lot more detail into that and the risks involved with it in the guide after the webinar as well.
Okay, thank you, Kira.
Yeah.
Haley, I hope that I asked that question right. If it wasn't clear, then Kira will provide more information.
Yeah.
So just before I go on to the others that have been asked, a previous question, which is a bit similar. So if a receptionist has started and the DBS check has been submitted but not returned, should she continue working, or should we stop work until the DBS is received? Now, I think that goes back to what you said, is don't let anybody start till you've got that information. Is that right?
Yeah, I would recommend, like, there is no law that states that an employee can start employment without a DBS. So there's not a law to say you can or can't. It just depends as well on the check that you need. So the advice that I would give is just have it all done before they start. I know DBSs can take some time, so just consider the role as well. So if it's non-clinical, the risk there might not be high because they're not going to be looking after your patients. Whereas clinical roles, I would be more of the opinion that you should try and have that DBS in place. And what you can do is, if you don't want to delay their start date, is accept their DBS from their previous employment, let them start, but still do your own DBS just to cover yourselves. But it depends on the role as well, and if they're dealing with patients or not.
Okay. So Laurella, how often should we repeat a DBS check? A number of staff who've been employed for many years don't usually repeat them. I think you mentioned that at the beginning, didn't you?
Yeah. So again, it does depend on the role, clinical versus non-clinical. It should be every 3 years, if I'm being honest. And then for those who work in a clinical role, probably every 12 months.
And is that the law? Is that the law, or is that just what as an HR guidance that you would give that?
It's guidance? Best practice, yeah. Again, DBSs, there's no real law. It comes down to the safeguarding issues. So you just need to make sure that they don't have any previous convictions that could put your patients at care. So, but there's no law, like you can't fail a DBS check either, you know. But again, it just comes down to the role. I would be advising your staff would be non-clinical staff every 3 years or so, and clinical staff more frequent checks.
Okay, thank you. So Sue's asked about administration checks, DBS checks for administrative staff. You've mentioned that, so yeah, you can have different levels of that. So if you did miss that, that'll be in the guide that we send out afterwards.
Yeah, that's a standard and basic DBS check required for that.
Yeah. Okay, one more here, Kiana. If someone is on the DBS update service, would we have to reapply if it has gone over 3 years? I don't know what the DBS update service is.
Neither do I. I'll have to look into that a little bit further for them.
Okay, Kiana will come back to you with that one unless you can add more information to that question. Okay, so Sarah said, our offer letter states satisfactory references. Example of a GP, the referees or colleagues, have asked for PM or lead GP partner, but those back have no context, just confirm that they've worked with them and that we're a nice colleague. Well, we've established that that's really all references are going to say anyway. Yeah. However, all the dates match, but the PM has not responded, and he states the lead GP didn't know him enough to give a reference. Does that sound like a red flag to you, Kira? Or
possibly, yeah, it's not really a reference you can rely on. So if they don't know him and the PM isn't responding, I mean, I'd be asking, the candidate themselves should be asking, well, why aren't they responding? Have they gotten in touch with them? Like, it shouldn't really be up to the employer to chase references. The candidate should really be doing that. So, for example, if I was to go for a job and my employer is asking me for a reference, I should be the one pushing for that reference to come through. So I possibly just ask that candidate or employee, they may already be employed, to push that a little bit more just to get that reference. And if they can't get an answer on that from that referee, look for someone else, ask for someone else.
Okay, thank you. Sarah was the one that asked about withdrawing an offer. So if they were unhappy with the references being supplied, and then that was the follow-up to that. So maybe you could have a conversation with Sarah offline about that. Yeah, if you wanted to drop me an email, Sarah. Okay, Linda has just said, we have just been told by CQC the DBS is non-transferable, so staff shouldn't start until the new DBS received. Well, it's not the law, is it? It's not non-transferable or transferable. It's just a recommendation that you should have one.
Yeah. Again, it just depends on what that role is. Like, is it clinical or is it non-clinical? What I can do with that is I can look into that more detail, because just going back to what I said earlier on, there is different standards for each role. So if you think about it, a receptionist is not going to be as high risk as, say, a doctor or a nurse who deal directly with patients. So your standard basic checks for your receptionists, the risk is low. You can get them done. You can accept them in, but the likes of your doctors, more frequent checks should be done there to ensure that they can safely deal with your patients from day one. But what I can do is I can look at that in more detail, Helen, offline for them if they want to talk.
Linda saying it was a receptionist. I think it just goes to that you just can't rely on just the DBS check, really. It's not, it's best practice to do one. And if CQC say that you need one, but obviously that's why all of the other checks are in, and that's why there's a safer recruitment policy. Making sure that you stick to that policy is really the best guidance, wouldn't you, really?
It definitely is, definitely.
Okay, if anybody wants to stay back, if there's any questions that they like to ask offline, then you're more than welcome to do that. We'll stay back for a few minutes as well. And again, if anybody's interested in any of the other support that we offer around recruitment, then you can obviously contact us as well. So thank you very much for attending. I hope you found it useful, and we'll send out the comprehensive guide as soon as it's ready and it's all been collated. So thank you very much.